This is the presentation for Chapter 8, Nursing Law and Liability. So ethics are expected behaviors of nurses, and laws are mandatory behaviors for nurses. With the rising number of lawsuits against nurses, the law can be intimidating, but the law is intended to help and protect people. So it can protect nurses, but it's important for nurses to know and understand the law so they are aware of what is expected of them. For instance, as we talked about the Nurse Practice Act on last week, which is a statutory law, which we'll discuss in a little bit here. You need to know what the Nurse Practice Act says because it tells you what you can practice or what's in your scope of practice as a nurse, so what you can and cannot do in your role as a registered nurse. So just remember that ignorance of the law is not a defense, it's not a legal defense in a court of law. You're expected to know what the law says. Statutory law is law that's developed by the legislative branch of the state and the U.S. Congress of the federal government. So like the Senate and the House of Representatives. An example of statutory law, like we just stated, is the Nurse Practice Act, which outlines a nurse's scope of practice. Common law is judge-made law. So that means decisions from previous legal cases form a precedent. And so a judge will look back on previous cases with similar circumstances to their current case to see how judges have ruled. And then they'll make their decision based on the precedent that has been set by previous judges. Informed consent is was actually developed from common law. Criminal law involves providing protection to all members of society, and the punishment for breaking a criminal law is death, imprisonment, fines, or restrictions based on the crime would determine, of course, what your punishment might be. If a criminal action is brought against a person, then it's between the person and the government. Civil law involves private individuals and results in payment of money to the injured person, a public apology, or even just implementing new standards. Civil cases are resolved in court, and the burden of proof lies with the plaintiff, who is the person that's bringing the complaint or the dispute. A tort is a wrongful act or an infringement of a right that leads to a civil legal liability. It can be intentional, meaning the person intended to cause harm to a patient, or unintentional, as when the nurse did not intend to cause harm to a patient. Intentional torts can be assault, which is when you threaten a person, a battery, which is when you actually touch a person. It can be false imprisonment, which is when a person, when you make a person stay in a place against his will, or using restraints or anything like that. And it could be physical or emotional abuse as well. Defamation of character is a quasi-intentional tort. So that means a quasi-intentional tort means it's a mixture of unintentional and intentional torts. So defamation of character, it can cause harm to a person's reputation. It includes slander, which is oral defamation. So you verbally say something against somebody. or libel, which is written. So you write something, maybe you put something on social media or something like that to damage their reputation. Invasion of privacy and breach of confidentiality are also quasi-intentional torts. To prove invasion of privacy, the person would have to prove the nurse intruded on the person's privacy. The intrusion was offensive to a reasonable person. The intrusion was uninvited, and it intrudes upon things that are considered private in nature, and the nurse publicly disclosed the information. Breach of confidentiality occurs when information is revealed from a privileged communication. So privileged communication exists between like a physician and the client, or the lawyer and the client, or something. A person cannot be forced under law to reveal information gained by a privileged communication. The legal system does not recognize the nurse-patient relationship as privileged communication. Statute of limitations is the specified time a malpractice suit can be brought against a nurse for negligence. The time usually starts when the injury occurred or when the injury was discovered. So if you didn't find out about the injury till a year or two later, then that's when the statute of limitations starts. So the time is usually anywhere from 1 to 6 years in most states. In Ohio, it's 6 years for felonies. Except murder, there's no statute of limitation for murder. And then usually 2 years for misdemeanor. In cases involving children, it can extend to it extends to the person is 21 years old. So the plaintiff brings a legal complaint, and the defendant is given due process, which is fair treatment in the judicial system. When the defendant responds to the complaint in writing, this is called the answer. The discovery process, that's the process when you're uncovering all the details of a malpractice suit. And the deposition is the process of getting everyone's testimony. Then the trial is the process of examining the evidence in front of a judge or jury, and that can take place years after the complaint is even filed, the actual trial. So negligence is conduct that falls below the standard established by the law, and malpractice is negligence by a professional. So negligence is just, conduct that's below the standard, and malpractice is when negligence occurs by a professional. So for example, a patient has a fall protocol in place and you did not follow that protocol, and the patient fell and maybe broke their leg or something, had some kind of injury. That could be malpractice. So 4 elements are needed to prove negligence. First, you need to prove that there was a duty. So we're talking about the nurse. So we have to prove that the nurse had a duty to do something. Then you need to prove that there was a breach of that duty. Then you need to prove that there were actually damages. And then you need to prove that there was proximate cause, which means because what the nurse did, these damages occurred. So in our situation when the patient fell, because the nurse did not follow the fall protocol that was in place for the patient fell and broke his leg. When we're talking about contributory negligence, that's just when the plaintiff is not allowed to receive money for injuries if they contributed to the injuries. Comparative negligence the award is based on the determination of the percent of fault of both parties. So, for example, the award is $100,000, and it's determined that the nurse is 75% at fault for the injury. Then the nurse pays $75,000 or 75% of that award, which would be $75,000. Assumption of risk is when the patient signs informed consent. It's assumed he understands the risk, and so as a result, if one of those risks occurred during the procedure, then you can't sue for it, because it's assumed that you were aware and you consented to those potential risks. The Good Samaritan Act, so healthcare providers that provide care in an emergency situation cannot be sued for injuries that might occur as a result. So, for instance, you see a car accident or whatnot, and you stop, or whatever, you see a person passed out, and you stop, help them, you start doing CPR on the person. As a result, from the CPR, they crack their ribs. They can't come back and sue you because you cracked their ribs. But at the same extent, you are held liable to the extent of your education. So, say for instance, a nursing assistant that provided care in that situation would not be held have the same liability as a registered nurse, because it's expected that a registered nurse would have more knowledge in doing different things. And to that same degree, a registered nurse would not be held to the same degree of liability as a physician would be. So they can't sue you if you did what was in your scope of practice and you followed what your scope of practice was, but you are held to the the degree or the extent of your educational level. The judicial overload is cutting back the percent of cases that's personally handled by judges. So this is done a couple of ways. You have mediation, which allows the parties to present their case in front of a mediator who is trained in dispute resolution and will help the parties find a common ground. Arbitration is when a neutral third party listens to both parties and makes a decision. Both the arbitrators and mediators are usually retired judges. Informed consent is when a patient is provided specific information prior to an invasive procedure. This is the physician's responsibility, not the nurse's. When given informed consent, the patient must be informed about the treatment being proposed, potential complications, alternative treatments, the desired outcome, and the consequences of not having the treatment. Some exceptions to informed consent are emergency situations when the patient is unconscious or incompetent, and situations when the physician feels it might be medically contraindicated. It might cause, serious injury or emotional distress or something. So a true emergency exists when a person will either die or have permanent injury if they're not treated immediately. If there's inadequate time to get informed consent, and the physician has to do what they need to do to save that life, it's assumed that a reasonable person would want their life saved. Intoxication can also prevent the physician from getting informed consent if the person's life is in danger. Patient Self-Determination Act requires all federally funded entities to inform patients of the right to prepare advance directives. So we talked about this in the last chapter, the living will, which is a legal document that describes medical or life-sustaining treatment the person wants when the client is no longer competent or able to make decisions due to illness. And then a medical durable power of attorney is a legal document that names a healthcare proxy to make healthcare decisions for a person if the person becomes incompetent or unable to make healthcare decisions. And remember, it has to be durable power of attorney for healthcare or medical, and not finance. A person that has durable power of attorney for finance cannot make medical decisions. A do not resuscitate is also a advanced directive, and so the physician has legal permission to write an order stating, no code or allow natural death or whatnot. That doesn't mean that they don't do things to help or care for the person, but should the person arrest or whatnot, they don't do CPR or anything like that. So SBAR stands for Situation Background Assessment Recommendation. It's used to help provide clear communication. It can be used for shift report, give a report to another unit when you're transferring a patient, or reporting to a physician. So in the situation, you want to identify yourself and discuss what's going on with the patient. In the background, you want to give key information in the patient's medical background to help give an understanding of what led to now. In the assessment, you give your actual assessment of the patient. In the recommendation, you give your recommendation of what should be done for the patient. So now, sometimes, physicians don't necessarily like getting a recommendation from the nurse, but it's a part of the SBAR, so you give the recommendation or whatnot, and they can always say, no, I don't want to do that or whatever. It's just a recommendation. So they can always say, no, I don't want to do it. But maybe, don't pose it as, I think you should do such and such. You can just say, well, what do you think about doing, X, Y, Z? Do you think that might help or something like that? So it's not like you're trying to, tell them what to do or anything like that. Sometimes, there's a second R. So if you are talking to the doctor and he gives you an order, then you repeat the order back. That would be with that if you did see a second R, it would be for repeat back the order. So of course, anybody can sue for anything, but there are some things you can do to try to prevent a lawsuit, such as documenting accurately. Your documentation is a legal document that can be used in a court of law, and it can help you or hurt you. That's why it's important you document accurately, because remember when we said before, it could be years down the road before your case goes to trial, and so you're not going to remember all the little details of a case from years ago when you're in court. And your documentation, it should be accurate, and it can be there to help you, and you should be allowed to, if the case does go to court, you should be allowed to review that documentation before you actually go into court. You want to develop a rapport with your clients. If you have a relationship with a patient and his family, they're less likely to want to sue you. They trust you more if you have that relationship there. They're more likely to forgive you. Make sure you stay confident and keep your skills up to date. The medical field is constantly changing, and you need to stay up to date. And then keep your clients informed about things, so they, won't have anything to complain about, or won't have a lot of things to complain about, or can't say they didn't know something. So keep your patients informed. Most facilities carry liability insurance for their nurses, but it might be good to carry your own liability insurance, just to have some extra insurance for a lot of different reasons. The jury might award the plaintiff something that exceeds the limit of your agency's coverage. Um, or your employer could pay out an award to the plaintiff and then turn around and countersue you to get their money back. Also, your employer's policy only covers you on the job. So, these are just a few reasons why you might want to consider getting your own insurance to have that extra coverage. The Federal Tort Claims Act states nurses who were formerly protected from lawsuits by working at federal or state healthcare facilities can now be sued for malpractice just like all other nurses as well. So the Board of Nursing can discipline nurses for a variety of things, such as criminal activity, negligence, violation of the Nurse Practice Act, drug and alcohol use. If you get disciplined by another board, the Board of Nursing can discipline you. Those are just a few reasons you might, could be disciplined by the Board of Nursing. So disciplinary action can be, you can have your license suspended, you can get fines, you can have your license revoked. The board will conduct a disciplinary hearing to review any charges brought against the nurse, and during that hearing, the nurse can present evidence in his or her defense. And they can have legal representation with them, during that hearing as well. And so it's usually recommended that you seek legal counsel for this hearing because your license is at stake with this.